So, what to expect at a status conference? Well, I'll say there's generally two ways that a status conference comes about. Either the parties request one side will file a declaration of readiness to proceed and request a status conference. The other way it comes about is when the board or the judge sets the matter for a status conference on the board's own motion. So let's first do an injured worker files a DOR for a status conference, or the insurance company defense attorney files a DOR for a status conference. What is it? Why do you do it? It's generally more of an informal setting. Oftentimes, the parties will have some sort of dispute, but not necessarily something that they want to take to trial immediately. Maybe the parties want to talk to the judge, get the judge's ideas. Maybe the parties have run into a situation they're just not quite sure how to handle, want to see if the judge has ideas, want to get the judge's suggestion. That will happen from time to time with unusual situations. Other times, maybe one party isn't responding to the other. The one party is trying to move forward with examinations or discovery, and it's not something that necessarily needs to be set for trial, but one attorney has reached out to the injured worker, or the injured worker has reached out to the insurance company a number of times, gotten no response. They can file a DOR for a status conference. It brings everyone together because you better show up when you're in front of the judge. The other type of status conference is when the judge sets the hearing on his own motion or on her own motion. That will take place if, let's say, a settlement is submitted and the judge issues an order suspending action. The judge will then set the matter for a status conference to discuss the settlement with the parties, see if the issues that the judge had, likely with regards to adequacy, but see if the judge's issues can be addressed with the parties. Other times, maybe after a trial or maybe after a petition of some sort has been filed, the judge may set the matter for a status conference just to bring the parties together with the judge to discuss what's going to happen. Those are the two ways you get to a status conference. So what happens at a status conference? I will say these days, under COVID, what will generally happen, the judge will usually start their conference calendar. So it will be status conferences, MSCs. It will also be lien conferences, all taking place during the same conference calendar, generally all starting at 8:30 or at 1:30. The judge will generally call each of the 10 to 15 matters, usually, go through them alphabetically, is the way that I did it when I was a judge. Go through, call for appearances, and I would ask if there were any joint resolutions. So the very first matter, Joseph Adams. So I would call that matter. I would call either the injured worker if he was in pro per, or I would call the applicant's attorney. I would call defense attorney, and I would ask if they had a joint resolution. If they did, I could take care of the joint resolution, dismiss both parties, and move on. If they didn't have a joint resolution, I would have them hang on until the end of calling roll call. So what I would do is call all 15 matters, all one after another, take care of any joint dispositions, and then I would circle back and start again at the beginning with anything that was still left over. So if there was no joint resolution. So if they didn't already have a joint agreement to go off calendar, or if they didn't have a joint agreement for a continuance, I would circle back. At that point, during a status conference or an MSC, I would then talk to the parties. What's the dispute in general? Keep it short. I would ask first whoever filed the DOR. I would ask next the opposing counsel or opposing party. If they still had a dispute, what I would usually do would be to send them offline, off the AT&T conference line, have them talk to one another, see if they could work out the dispute, and then call back at a designated time. So if they were at the 8:30 calendar, I might have them call back at 9:15. At 9:15, when they called back, I would again ask if they had a joint resolution. Ideally, everything would be worked out. If not, I would then listen to whatever the dispute was, hear both sides, if I could offer insight, and work the parties to an agreement. That was always my goal as a judge. So if I could get them to a joint agreement to go off calendar or a joint agreement for a continuance, that was the goal. If not, then I had to make a decision. So at a status conference, the judge does not usually close discovery. That's only going to happen at an MSC. The judge does have the power to convert a status conference into an MSC, but that is not something that happens very often. So usually at a status conference, probably 99 times out of 100, we would either agree to go off calendar, and I would take the matter off calendar. The parties could work on settlement, discovery, whatever it was they were working on. Or I would continue the matter so that I could bring the parties back a month, 2 down the road, maybe 3 months, depending on how backed up the calendar was. And we could discuss the issue again. I could find out if the parties were able to come to a resolution on that dispute. So that's a status conference, generally more informal. It's still all being taken place, all being handled over the AT&T conference lines, unless the judge chooses to move into life-size cloud, into the video program. Most aren't doing that at this point. So it's still all over the telephone, usually a little more informal, likely going to end with either a continuance or an OTOC. And I will say that it can get continued to an MSC. Let's say there's a dispute. It really does need to be set for trial. It was set for a status conference. I could, as a judge, continue the matter and have the next hearing be an MSC. So that's one option as well. But that's generally it. At a status conference, either requested by the parties to all come together and talk, or requested by the judge to address issues, usually going to go off calendar or be continued. If you have other questions, drop us a comment down below. And if you like this video, hit the like button.